The courtroom had been quiet for 11 minutes when the janitor stood up and corrected the lawyer. Not loudly, not dramatically. He simply raised one hand, the way a student does when the teacher has written the wrong answer on the board, and said, "Counselor, that statute was amended in 1987. You're citing the original text." Nobody laughed. Nobody moved. The lawyer, a man named Sterling Boyce, who had never lost a civil case in 14 years, turned around slowly and looked at the man holding a mop. "Excuse me?" "Section 4, paragraph C," the janitor said. It was revised after Whitmore versus the city of Memphis. The burden of proof shifted to the plaintiff in cases involving municipal employees. "You're arguing the wrong version of the law." Sterling Boyce stared at him for 3 full seconds. Then he looked at the judge. Then he looked back at the janitor. "Sir, this is a courtroom, not a community college." The janitor nodded once. "Yes, sir, I know." He picked up his mop and went back to cleaning the baseboards near the door. But the judge had heard every word. Theodore Briggs had been cleaning courtroom 4 in the Shelby County Courthouse for 9 years. He arrived at 6:15 every morning, before the lawyers, before the bailiffs, before the coffee finished brewing in the break room down the hall. He swept the gallery benches, mopped the hardwood floor that creaked in the same 3 places it had always creaked, and wiped down the brass railings with the same cloth he'd been using since his 2nd week on the job. He was 67 years old, 5'9" and thin, in the way that men get thin when they've been carrying weight for too long, and the weight finally left them. He wore reading glasses on a lanyard around his neck and kept his gray beard trimmed close. His left hand had a slight tremor, from a nerve injury he'd never had fixed properly. He walked with a quiet kind of deliberateness, like a man who had learned long ago that moving fast didn't mean arriving sooner. If you passed him in the corridor, you would hand him your coffee cup without thinking. That is what people did. With Theodore Briggs, they handed him things. Trash, dirty cups, wet umbrellas. They thanked him without looking up. He never complained. He had his reasons. 11 years ago, Theodore Briggs was something else entirely. For 26 years, he had been a professor of constitutional law at the University of Tennessee College of Law. He had argued 3 cases before the Tennessee Supreme Court. He had published a textbook, Civil Procedure and the American Municipal System, that was still assigned reading in 14 law schools. He had trained more than 400 students who now practiced law in courtrooms across the country, some of them in this very building. Then, his wife, Constance, got sick. ALS. Amyotrophic lateral sclerosis. The doctors said 2 years. She lasted 4 because she was stubborn, and because Theodore sat with her every night and read to her from whatever book she chose, even when she could no longer hold a page herself. When she died on a Tuesday morning in late October, Theodore folded his academic gown, placed it in a box, and did not open the box again. He retired early. His daughter Renata had moved to Memphis after her marriage, and Theodore followed. He needed to be near family. He needed something to do with his hands. The courthouse was 3 blocks from his apartment. They were hiring. He took the job. He did not tell anyone what he used to be. Renata knew, of course. Her husband, a contractor named Vernon, knew. But Theodore asked them to say nothing, and they respected that. He wasn't hiding. He was resting. There is a difference, though not everyone understands it. For 9 years, he cleaned floors and listened. He listened to lawyers argue over procedural points they'd gotten wrong. He listened to judges explaining rulings in language that didn't quite match the statute. He listened to young associates speaking to clients in tones they would never use if they thought anyone important was in the room. He never said a word, until the morning of April 14th. The case was routine, at least on paper. A municipal worker named Cedric Webb had been terminated from his position with the city sanitation department after a workplace injury. His union had filed a grievance. The city's legal team, led by Sterling Boyce, argued that the termination was lawful under the original language of the employment statute. The union's attorney, A young woman named Priscilla Tate, who had been practicing for less than 3 years, was doing her best against a firm with 12 times her resources. Theodore had cleaned courtroom 4 every morning for 9 years. He had watched hundreds of cases. He had seen good lawyers and bad ones. He had seen judges who were sharp and judges who were checked out by 10 in the morning. He had never spoken up, not once. But that morning, from his position near the door, he watched Priscilla Tate build her entire argument on a statutory interpretation that Sterling Boyce had already anticipated, because it was wrong. Not wrong in a subtle way, wrong in a foundational way, the way a building is wrong when the load-bearing wall is in the wrong place. Everything she had prepared, every exhibit, every witness, every line of her opening argument, rested on a reading of Section 4 that had been superseded nearly 4 decades ago. Theodore knew this because he had written a 40-page journal article about Whitmore versus the city of Memphis in 1991. He watched her speak. He watched Sterling Boyce take notes with the comfortable efficiency of a man who knew he was about to win. He watched Cedric Webb, 54 years old, sitting at the plaintiff's table in a shirt that was slightly too big for him, the kind of shirt a man buys when he's lost weight from stress. He raised his hand. "Counselor, that statute was amended in 1987. The room did not go immediately quiet. It went through several stages. First, confusion. Then irritation. Then a specific kind of silence that falls over a room when something unexpected has landed, and nobody is sure yet what it is. Sterling Boyce did not lower his voice when he responded. That was intentional. "Sir, I don't know what you think you heard, but legal proceedings are not open to commentary from the maintenance staff. Bailiff, can we please?" Judge Alma Sherwood raised one hand. She was 61 years old, 22 years on the bench, and she had a quality that good judges develop over time. She knew when to let something continue. "Let him finish," she said. The courtroom went fully quiet. Theodore set his mop against the wall. He didn't move closer. He stayed by the door where he always stood. "Whitmore versus the city of Memphis, 1987, he said. Tennessee Supreme Court. The court held that the burden of proof in wrongful termination cases involving municipal employees shifts to the plaintiff only when the employee was terminated for cause that predates the injury. In all other cases, the municipality bears the burden." The statute was amended to reflect that holding the following year. Counselor Boyce is citing the pre-amendment text. That version of the law no longer applies. Nobody in the room breathed. Sterling Boyce turned to face Theodore fully now. His expression had moved past irritation into something harder. "And you know this because I wrote about it," Theodore said. "Briggs, T.A., Municipal Employment Law and the Shifting Burden. A Post-Whitmore Analysis, Tennessee Law Review, Volume 58, 1991. Page 214. It's in the case reporter, if you need the citation." Priscilla Tate had stopped writing. She was staring at him. She looked like a woman who had just realized she was standing on solid ground when she'd expected to fall. Cedric Webb turned around in his chair and looked at the man by the door. Sterling Boyce looked at Judge Sherwood. Judge Sherwood looked at Theodore. "Sir," she said with a precision in her voice that the room recognized immediately, "what is your name?" "Theodore Alcott Briggs," he said. "I clean this courtroom." A pause. "And before that?" "Constitutional law.
He said,
University of Tennessee. 26 years. The silence that followed was different from the ones before it. It was the kind of silence that fills up fast. What happened next would be described later in 3 different ways, depending on who was telling the story. Sterling Boyce's version, a procedural irregularity, quickly corrected, no real impact on the case. Priscilla Tate's version, the moment the floor appeared under her feet. Cedric Webb's version, a man by the door gave me back something I thought was already gone. Judge Sherwood called a 30-minute recess. She sent her clerk to retrieve the case reporter. Theodore waited in the corridor, still holding his mop, while 2 law clerks verified the citation on a tablet with increasing expressions of disbelief. The Whitmore precedent was exactly where Theodore said it was. The amendment was exactly what he described. Sterling Boyce's entire statutory argument rested on a version of the law that had been superseded before he graduated from high school. When the session resumed, Judge Sherwood issued a formal advisory to both parties regarding the correct interpretation of the statute. She noted, with what appeared to be deliberate calm, that she expected all subsequent arguments to be grounded in current law. Sterling Boyce adjusted his argument. He was good enough to do it in real time, but the adjustment cost him. The case had a different center of gravity now, and he knew it. Priscilla Tate rebuilt her position around the correct statutory framework. She was nervous, but she was sharper than she'd been an hour ago. The kind of sharp you get when someone hands you solid ground and tells you to stand on it. At 4:17 that afternoon, Judge Sherwood ruled in favor of Cedric Webb. Full reinstatement. Back pay for 14 months. Legal costs awarded to the plaintiff. Cedric Webb sat at the table after everyone else had stood up. He was very still. The kind of still that comes after you've been waiting for something a long time, and it finally arrived, and your body doesn't quite know what to do with the relief. Priscilla Tate shook Cedric's hand. Then she walked to the door, where Theodore was putting on his jacket, preparing to leave the way he always did, quietly, before the room emptied. "Mr. Briggs," she said. He turned. "Thank you," she said. I don't know what that was." "You had the right instincts," he said. "You just needed the right statute." She looked at him for a moment. "Can I ask you something?" "You can." "Why are you cleaning floors?" Theodore Briggs looked at her. There was no bitterness in his face, no performance of humility. Just a man who had made a choice and was at peace with it. "My wife used to say the best way to understand a place is to maintain it," he said. "She was right about most things." He picked up his cart and pushed it down the corridor toward the elevator. Priscilla Tate was 29 years old and had not yet developed the professional habit of letting things go. She went home that night and searched Theodore Alcott Briggs in every legal database she had access to. She found the 1991 Law Review article. She found the textbook. She found a photograph from a 1998 faculty convocation. Theodore standing in the third row, younger, broader, in the shoulders, with Constance beside him in a green dress, both of them laughing at something off camera. She found his retirement announcement from the University of Tennessee, 2015, 2 paragraphs, no fanfare. She found his wife's obituary, Constance Marie Briggs, October 23rd, survived by her husband Theodore and her daughter Renata. Priscilla sat with that for a long time. The next morning she arrived at the courthouse at 7. Theodore was in courtroom 4, as always, running a cloth along the brass railing. She stood in the doorway. "I read your article," she said. He kept cleaning. "It's dated, I'm afraid. The core argument isn't." She stepped into the room. "I also read your textbook, the chapter on municipal employment liability. I had 3 cases last year where I argued the wrong standard. I didn't know." "Most people don't," he said, without reproach. "The amendment doesn't get taught well. You could teach it." He was quiet for a moment. "I'm teaching it right now," he said, "in the only way I know how to anymore." She didn't push, but she left him her card on the railing. The story would have ended there, and Theodore would have preferred that it did. But Sterling Boyce was not a man who lost gracefully. Within a week, a complaint appeared on the courthouse employee conduct portal. Anonymous, but the language was Boyce's. It alleged that a maintenance employee had improperly interfered with active legal proceedings, providing unlicensed legal commentary that influenced the outcome of a case. The complaint called for a formal review. It suggested that Theodore Briggs had deliberately concealed his legal background in order to insert himself into proceedings under the guise of a civilian bystander. The review was assigned to the courthouse administrator, a careful woman named Helen Voss, who had been in her position for 15 years and had seen this kind of thing before. She called Theodore into her office on a Tuesday morning. He came in his work uniform. Blue shirt, gray trousers, name badge. "You understand what's being alleged," she said. "Yes. Do you want to respond?" I'd like to know if I did anything wrong, he said. Helen was quiet for a moment. She had read the transcript. She had read the case ruling. She had looked up the Whitmore precedent herself, just to be certain. You stated a legal fact in an open proceeding, she said. You identified yourself when asked. You didn't advise either party. You didn't offer an opinion. You cited a published source that anyone in that room could have verified. That's correct. Then no, she said. I don't believe you did anything wrong. She closed the file. But Mr. Briggs, I have to ask, why didn't you tell anyone who you were? Theodore thought about this for what seemed like a long time. People treat a professor differently than they treat a janitor, he said. I wanted to see this place the way it really was, without the deference. And what did you see? The same things that happen in any institution, he said. Good people trying hard. Some people who stopped trying, and a few who never tried to begin with, but got good at looking like they did. Helen Voss looked at him across her desk. The complaint will be dismissed, she said. For the record, thank you. He stood to leave. Mr. Briggs, she said. He turned. The Bar Association has a pro bono mentorship program. They've been looking for someone with appellate experience to advise younger attorneys on municipal law. She slid a brochure across her desk. No pressure. He looked at the brochure. He looked at his name badge. He thought about Constance. He thought about Priscilla Tate standing in the courtroom doorway at 7 in the morning with a legal database and a question she hadn't known to ask until yesterday. He picked up the brochure. I'll think about it, he said. Sterling Boyce filed a formal appeal of the Webb ruling. He hired a second attorney to assist. He issued a statement to the local legal press, suggesting that the original proceeding had been compromised by an irregular courtroom incident. He implied, without stating directly, that Judge Sherwood had shown poor judgment in allowing a maintenance worker to address the court. The Tennessee Bar Association reviewed the appeal. They also reviewed something else. A pattern of conduct in Sterling Boyce's previous 17 cases involving municipal defendants. A pattern that Priscilla Tate, working with a retired law professor who had begun coming into her office 2 evenings a week to review case files, had spent 3 weeks documenting. Cases where Boyce had cited outdated statutes. Cases where discovery materials had been submitted incomplete. Cases where the opposing counsel had been less than 3 years out of law school. It was not always the wrong law. Sometimes it was the right law used the wrong way. The kind of thing that requires a very specific depth of knowledge to catch. The kind of knowledge that, say, a man who had taught constitutional law for 26 years and then spent 9 years quietly listening in the corridors of the same courthouse might possess. The Bar Association's review took 4 months. At the end of it, Sterling Boyce received a formal censure for repeated citation of superseded statutes in active proceedings. His firm was required to implement a case review protocol overseen by an outside compliance monitor. The Webb appeal was denied. Cedric went back to work. Theodore Briggs started the mentorship program on a Wednesday in June. He kept his custodial job. He worked mornings, taught 2 evenings a week, and on Saturday mornings he reviewed case briefs in Priscilla Tate's office, drinking the bad coffee she kept apologizing for. He never apologized for the coffee, he just drank it. The day the Bar Association's censure of Boyce was published in the Tennessee Bar Journal, Renata called him on her lunch break. "Dad," she said, "you're in the article. I know. You're described as a custodial employee with extensive legal expertise. That's accurate, Dad." There was something in her voice. Not quite crying. The sound of a person pressing tears back behind something quieter. Mom would have loved this. She would have framed the article. Theodore sat in his apartment on the 6th floor, looking out at the same view he'd looked at for 9 years. The courthouse 3 blocks away, the same streets, the same sky. "I know," he said. "She always said I was wasted on tenure committees." Renata laughed. Then she stopped. Then she said, "Are you okay? Are you really okay?" He thought about the question the way he always thought about the questions that deserved real answers. "I think so," he said. "I think I'm starting to be." He went to class that evening. 7 young attorneys sat around a conference table in a room that smelled like dry erase markers and stale pastry. Some of them were nervous. One of them had already made a mistake in a brief that would cost his client 2 weeks of delay if it wasn't caught. Theodore caught it. He showed the young man where the error was and how to fix it. He did not make him feel small. He did not pause for effect. He did not perform the correction for the rest of the room. He just fixed the problem, quietly, the way he had always done everything. The way his wife taught him. The best way to understand a place is to maintain it. 6 months after the first class, 14 attorneys had completed Theodore Briggs's municipal law seminar through the Bar Association's pro bono program. 3 of them had since won cases they would have lost. 2 had identified statutory errors in opposing counsel's filings before the errors could do damage. 1 had cited the Whitmore precedent correctly, for the first time in her 4-year career. On the last night of the second cohort, the group stayed late. Someone had brought good coffee, finally, and they stood around the conference room table with their cups and talked about cases that had changed how they saw their work. Theodore sat at the end of the table. He was still wearing his custodial badge. He'd come from a closing shift. Someone asked him what made him decide to speak up in that courtroom after 9 years of saying nothing. He thought about Cedric Webb's shirt, the one that was too big because the man inside it had been worn down by waiting. "I'd been watching long enough," he said. "There's a point where watching becomes complicity. I didn't want to reach it." A woman near the window asked a second question. "Do you regret not speaking up sooner? In other cases?" He held his coffee cup with both hands. The left one trembled, the way it always did. "Every day," he said. Then, after a pause, "But you can only start from where you are." The room was quiet. That was the answer they needed, even if they hadn't known to ask for it. I've thought about this story a lot since I first heard it. I keep returning to the same moment. Not the courtroom, not the ruling, not even the censure. I keep coming back to the 9 years. 9 years of arriving at 6:15. 9 years of wiping down railings and mopping floors and listening to the law being practiced by people who didn't know they had an audience. 9 years of saying nothing. That is not failure. That is grief doing what grief does. Taking up space, asking for time. And when the time came, Theodore Briggs didn't rush. He didn't make a speech. He raised his hand, the way a student does, and stated a fact. That's what real knowledge looks like when it finally steps out of the dark. Not a performance, not a declaration, just a quiet correction in a room where the right answer had been missing long enough. If someone in your life has been carrying something nobody else can see, a history, a skill, a decade of hard-earned understanding that the world walked past without looking, I want to hear about them. Tell me who that person is, because this channel exists for exactly them. Share this with someone who needs to hear it today. Maybe they're sitting on something. Maybe they've convinced themselves it's too late. Maybe they just need to know that starting from where you are is enough. And if you want to be here for the next one, subscribe and hit the bell. Next week, I'm bringing you a story about a woman who spent 30 years as a hotel housekeeper and walked into a city council meeting that changed her entire neighborhood. You won't want to miss it. Standing up doesn't always look like a fight. Sometimes it looks like a man raising his hand in a quiet room and saying, "Actually, that's not right. Let me show you."